Hello and welcome to US LawShield live here on YouTube. We are excited to be here with you. I'm independent program attorney Richard Hayes, joined by the brilliant and beautiful Emily Taylor. Good morning, Emily.
Good morning, Richard.
All right, well, we are so excited to be here with y'all today. We're talking self-defense. Now, we've had quite a few of these live discussions, and we get all kinds of questions as they come up, and we try to stick to the topic we're on. But in the past discussions, we had so many questions about self-defense, we knew we had to talk about it. So we're excited to be with you. We're going to cover some myths that I think a lot of people ask questions about. We're going to cover the basics, but we're excited for you to be here. Now, we are getting the questions fed to us live right here. So if you're watching this stream, make sure to leave a comment. If you're just saying hello, where you're from, that's great. But if you have a self-defense question, make sure to post that question in the chat. Hopefully it makes it to me. Post them early so that we can get to all of your questions.
And if there's something that we didn't reach, something that you're really curious about, you can always go to uslawshield.com. Check out their educational resources. There's a ton on the website, and you might get your question answered there as well.
Yeah, that's a very, very good point. Now, let's start our conversation off. Now, the number one question, and we're big topics here, but when we say what is self-defense when we're talking about self-defense?
Yeah, so when we're talking about self-defense, we're talking about someone else is using some kind of unlawful force, up to deadly force, right, against you. And bear in mind, we're talking about unlawful. That's the key here. And I think the first thing that comes to my mind when I think about, well, what's lawful force against me? First thing comes to my mind is being arrested, right? Someone's using some sort of force against you. That doesn't mean you can use self-defense against the police. Now, many states have exceptions, and I think we probably won't even touch that today. But someone is confronting you with unlawful force or unlawful deadly force, and you have this God-given right to self-preservation. So, I mean, that's what comes to mind for me.
Yeah. Self-defense, when people say, hey, broadly, what is self-defense? I think about it as a justification. This may bleed into our kind of next question that comes up, but it's a justification to what would otherwise be considered a crime when I think about self-defense, because our general rules, general rule, not allowed to punch somebody, not allowed to tackle somebody, not allowed to restrain them, not allowed to pull a gun or display or brandish or even pull the trigger, shoot someone, kill someone. Those are our general rules of society. We all got to play by those rules. But sometimes the law says, hey, this is okay because, and that's what we're going to be talking about, self-defense. So the next question that I think comes up a lot of times, and people are surprised, and that's why we have to start with the groundwork of justification, is, can I go to jail if I act in self-defense?
Right. And this plays a little bit into what you were just saying, which is that it's a justification. And, we all hear stories, we see things in the media where, you use self-defense and the person's never arrested, never charged.
Yeah.
That's great when that happens. But because the way the law is written in basically all 50 states, it doesn't have to happen that way, because essentially you are we say it's a law of admittance and avoidance, right? Yeah. You have to say, yes, I punched Richard. Yes, I shot Richard, right? Not, I
hope not.
Hopefully never. But that's how you have to, you have to admit your conduct, and then you have to prove that you acted in justified self-defense. And one of our questions here that we had, sort of pre-populated from other sessions is basic self-defense laws. We're going to get into that in just a second, but you've got to prove it. And that often includes being arrested, being charged, often going in front of a jury. I mean, we've seen a couple high profile examples of that recently. Kyle Rittenhouse just a couple months ago. That's a really good example of, having to be put through all of your paces just to prove that you were defending yourself.
And I think that's a good point that you raised, is the plea and abatement. I think a lot of people, and maybe you see these in court dramas or in TV shows or in movies, where they say, it wasn't me. But if it was me, I was in self-defense. And so I think that's an important point to reiterate, that when a person's claiming self-defense, they're admitting to generally the conduct itself, and they can't, hide behind the, hey, it wasn't me.
Yeah.
So, I think that's important to point out.
Yeah. And I think let's skip down. So, because I think we really need to start into a little bit of meat and potatoes of
I think so.
Basic self-defense law. And there are a couple elements we were actually just going through this morning talking about it. Do you want to start with those and we'll walk through them?
Yeah. So I would say the first one is immediacy. That's the first one that comes to my mind, is that it has to be immediate. And now we don't have, and most courts are not going to define immediate, but they're going to say imminently necessary or immediately necessary. They're going to use different terms, but we see this element show up time and time again across the law. We've reviewed virtually every single state's self-defense law, and that term almost always shows up. And like I said, we don't have a definition from it. Black's Law, they have lots of different Black's Law. I think the 13th edition has my favorite definition of this, but it's when you have to act right away without delay, without being able to call for help. And so you have to act right now in the moment.
And I mean, we see this. There's a spectrum of when people don't act with immediacy.
Yep.
And we see this in everything from, hey, the next time I see you, I'm going to do this thing, right? Well, you can't act in that moment because it's not an immediate threat. To, I mean, gosh, we've had people walk inside their houses to retrieve weapons and then come back out. Well, you've really killed your immediacy in a lot of situations there.
Yep.
And then, everything from, you are a threat, you are right there, but are you too far away? Are you not giving me enough indications that you are about to act? I mean, it's really a spectrum of situations that the state could use against you and say you weren't acting with enough immediacy.
Those are great illustrations, because when we see, a self-defense case fail, on the issue of immediacy, that's exactly right. It's because the person acted too soon or they acted too late.
Oh, yeah.
And so, you're at a gas station pumping gas and some guy says, hey, can I have a buck, and starts walking towards you. If you pulled your gun and shot that person, all right, you're going to go to prison for murder. Right?
Oh, yeah.
Because obviously that would be too soon. But let's say it progressed. The person comes at you aggressively, pulls out a knife and says, I wasn't really asking. Then that changes the circumstances. Or, an example of too late. Let's say the person, robs you or robs, our gas station person. If they took off running around the corner, if you chased after him and shot him at that point, would that be immediately necessary anymore?
Right. Yeah. I mean, it's tough. And I think, we can talk about our next basic self-defense law element too, which is proportionality.
Good one.
Right.
Yep.
I mean, that's something that comes up in every state, in virtually every situation, which is you must be acting in proportion to the unlawful force or unlawful deadly force that you are encountering.
Yeah.
And we see this a lot too. I mean, think about situations where, someone comes up to you and they shove you. If you unholster your gun and you shoot them, that is probably, and I say probably, there are exceptions to every situation. That's why lawyers exist, right? But that is probably not proportional. So even though it's immediate, even though it's unlawful force, you are likely not going to be found to have used reasonable self-defense because you didn't act with proportion. And I'll ask you if you have a different take on this, but my general definition of proportionality, at least when I try to explain it to people, is you have to act with as little force as possible to stop the person from doing what they did. And oftentimes I like to think of it as just a featherweight more than what that person did to you. Do you have something different you tell people?
No, I think that's a good explanation that and I see that in my practice too, using the least amount of force necessary to stop the threat is going to serve you well if you find yourself in a self-defense situation. The only thing that I wanted to add was, we see this spectrum of force. And our law doesn't do a good job, I think, of breaking force down when it comes to proportionality or different building blocks, because we have everything from, assertive verbal commands to, discharging a firearm intentionally at a person, and everything in between, mace, fists, knives, clubs, and it builds up this spectrum. And what we see in our law over and over again is it tries to simplify it and kind of put these things into buckets, and in most states it's either going to be force, maybe this end of the spectrum's down here, and deadly force, it's going to put everything in a different bucket up here. And some states have an intermediate standard, but that makes it real tough because it seems like such an all or nothing proposition if you're forced to defend yourself, wouldn't you say?
Oh yeah, absolutely.
And the other thing that I'd add to that is, and I'll bring up warning shots as a good example, because if you would be justified in using force, a warning shot doesn't feel like a use of deadly force, but most states are going to say, for example, a discharge of a firearm, always going to be a use of deadly force. And so we got it in that big bucket there. But at the same time, maybe it's not reasonable and immediately necessary. Going back to our immediately necessary.
Oh, yeah.
Yeah, tell us about that.
Yeah, so I mean, warning shots are a great example of when you really cut off your immediacy at the knees
Right.
when you use a warning shot, because you have to, right, and this is true in virtually every jurisdiction, to shoot a warning shot, you have to have been able to shoot the person, right? You have to have been able to kill them legally.
Yeah.
And so if you have time to fire a warning shot, have you just proven to your jury that it wasn't immediately necessary to use deadly force because you had time to fire a warning shot, right? Which is going to be the prosecutor's argument every single time.
Yeah. No, and I think so that's a good illustration of, hey, look, it feels like it would be less force. Proportionately, it feels like less force than, if you had intentionally aimed at a person and discharged.
Sure.
But what we find is maybe it's going to be put in that big bucket. And so that part kind of scares the heck out of us.
Oh, yeah. Well, and I think, just if I can build on this general self-defense discussion too, because I think we're on a good roll.
Yeah.
We've got, you have to act with immediacy.
Right.
You have to act with proportionality.
Right.
And then we have this gigantic catch-all, right, which is that your use of force or deadly force, whichever bucket you've got, has to be reasonable in response to what you're confronted with. And I mean, those are, when I try to just explain self-defense law generally, those are my three big ticks to take off, right? Proportional, immediate, and reasonable.
Right.
And reasonable is tough because, I mean, some states like Texas, we have a definition for it, but the definition's not really helpful, right? We're talking about, would an ordinary and prudent man in your circumstance have acted in the same way that you did, which is fine, but I mean, what does that really tell a jury? A jury still gets to decide who's ordinary and prudent, right?
The way that I think about, and that's the ordinary, reasonable person standard. What I like to think that a jury would do is they would envision, who is this ideal reasonable person, just not necessarily similarly situated as the defendant, but what would a average person do? They kind of come up with this hypothetical person and say, what would this hypothetical person have done if they were in all these same circumstances? And then they compare, the defender's conduct to that hypothetical person. And if their conduct lines up, great, justified self-defense. And if their conduct is way off, then maybe it's a different story.
That's not what your jury's doing.
No, I will tell you.
Your jury is saying, would I have done it?
Yes.
Right? And if the answer is no, and maybe what's scary is maybe the answer is no because you've got kind of an anti-gunner on your jury, right? Or someone who doesn't agree that, you do have that inalienable right to defend your own person.
Yeah.
But they're not going to say, all right, well, I myself am unreasonable about self-defense or about firearms. Yeah. What would they're going to say, would I have done it, right?
No, exactly.
Which is what's scary about even getting in front of a jury in the first place.
The next factor that I think is worth discussing is this, you brought it up at the very beginning, is responding to an unlawful force, an unlawful threat. What comes to your mind when we say, hey, you're responding to an unlawful threat?
Well, the first thing, other than, probably don't use self-defense against police officers unless we're in a really crazy situation, even though most states' laws have, some sort of exception there. It's just generally let us fight in court. Don't do that on the side of the road.
Exactly right.
But the thing that comes up for me most often is what's not unlawful force.
Right.
And in virtually every jurisdiction, that's words alone, right? Which is tough because, I mean, sometimes it's just someone being kind of a jerk, and that's easy to distinguish. Like, you can't hit somebody because they're being sort of a jerk to you. But maybe they are really making threats against you, but it's just verbal, and there's no present ability to act. There's no indication to you that they are about to act on those threats. That's not unlawful force such that you can respond physically.
Yeah. And when I think, going back to this element, unlawful force, I think, would the first person who uses force be justified? So for example, if you're a trespasser, and the person says, hey, get off my land, and is holding a firearm, if you were to attack the landowner, are you responding to unlawful force in that situation? Probably not.
Probably not.
No, because the landowner has a right to be present on their land. They have a right to be possessing a firearm. And so if you were to, essentially defend yourself in that situation, would it qualify as a justified self-defense? Probably not. That's what comes to my mind. So what can you, and this brings up kind of the next, and it ties in with proportionality a little bit, and we have a couple of questions about it, so I want to talk about it, is what can you use as a weapon for self-defense? Or, what does the law look at when you use something other than your hands in self-defense.
Yeah. Gosh, I mean, anything that you can legally possess is a self-defense tool, right? So, you know, and there, of course, I mean, you're not helping yourself if you use items that are unlawful to possess. You know, if you use your meth pipe in self-defense, there's going to be issues there, but you can still use it. It's still a tool, right? But anything that's legal to possess. So, and, you know, I think that gets us into a little bit of a discussion of what is a deadly weapon, right? Because that's also pretty much anything based upon, did it cause serious bodily injury or death?
Right.
And, you know, in the way that you used it, did you intend it to, right? So we're talking about, I mean, not just hands, feet. We're talking about, you know, we've had several clients who have used their teeth in self-defense.
Yep.
Those have been alleged actually to be deadly weapons. You know, frying pans, baseball bats, you know, that issue at the synagogue, the hostage taker at the synagogue, the rabbi threw a chair in self-defense. That was a great self-defense tool under the circumstances because he didn't have anything else. Fire extinguishers. I mean, virtually anything is your self-defense weapon.
Right.
But just, you know, like here in Texas, zip guns are absolutely illegal. Try not to use a zip gun in self-defense because you're not allowed to possess them anyway.
Right. And so, and I think that, because we got a question about, you know, bear spray or, you know, if they're confronted by multiple attackers. I think the biggest factors, you know, some things are always going to be considered deadly weapons, you know, firearms, knives. Yeah, virtually always. And then for everything else, it's how do you use this item? And are you using it in a way that would cause serious bodily injury or death, like you said? And so the example I like to give is a pillow. You know, a pillow.
It's a good one.
Yeah, not a traditional deadly weapon, but if you hold it over somebody's face and suffocate them to death, well, then, yeah, that's going to be considered a deadly weapon and how you use it. And so, you know, going back to those buckets, you know, if we have a non-traditional deadly weapon, you know, the way that it's used, the injury that it causes, it's going to decide what bucket. Does it fall into a use of force or does it fall into a use of deadly force?
Yeah.
And I thought those are very good questions y'all all had.
Yeah, sure.
So let's get to a couple of these myths, and then these questions are piling up. We got to start hitting these questions. So a myth that we got, you know, in one of our last discussions, let's start here. Is wasp spray better than pepper spray?
Yeah, so this is a really good one because you hear this a lot. You hear, you know, buy wasp spray, buy bear spray, keep it with you, use that as your self-defense tool because, you know, various reasons why it might be more effective against your attacker. I discourage it. I don't know if you discourage it as well. But, you know, it really is, you know, when we're talking about these buckets we've been talking about, force versus deadly force. I think that, you know, deadly force doesn't just encompass killing people, right? It encompasses causing people serious bodily injury, which includes things like permanent disability, disfigurements,
loss of use of organs,
permanent scarring, things like this. So, I mean, you can imagine how, and I'll let you kind of elaborate how wasp spray might actually fall into that bucket.
Well, I would start with it's designed for wasps. It's not designed for the human eye. And so, you know, if you were to use wasp spray and if it were to cause blindness or cause some kind of permanent, you know, protracted loss of the use of vision or something like that, it's going to be serious bodily injury. I think virtually every state's going to consider it serious bodily injury if that were to occur. And in that case, you would have to be justified in killing the person.
Right.
And so at that point, it almost goes back to our warning shot example. While it feels like a lesser use of force, you know, it's getting grouped in with all these other uses of deadly force. And, you know, your conduct would have to be justified. In a sense, you'd have to be justified in using deadly force at the end of the day.
Right.
And so,
if it causes that serious bodily injury, which it's likely to do.
Yes.
And, you know, bear in mind, too, that there are all sorts of things that can affect how your jury views this.
Right.
I mean, if you are out in your yard killing wasps and you are attacked in such a way that that is your only self-defense tool, I mean, by all means, use it, right? We're not telling you not to use it. But, you know, if that's what you're carrying around in your vehicle and it's clear that that's your self-defense tool of choice, your jury's probably going to look on that a little bit differently than if it's the weapon of opportunity rather than the weapon of choice.
They make some, I mean, extremely effective, you know, mace and chemical sprays for humans, you know.
Yeah.
And virtually all of those are going to be considered a use of force.
Correct.
And so that lowers your threshold for, hey, was my conduct okay? It lowers the threshold on that. You know, if you would be justified in using force, then typically you'd be justified in using, you know, mace, for example. And that kind of goes along with the same example, tasers, for example.
Oh, yeah.
You know, tasers, generally a use of force, but tasers have killed people.
Sure.
I don't know if you've seen the video of a person was tased, and I think they had rubbing alcohol on themselves, or they had hand sanitizer on, and they caught on fire, and they ended up dying. And so in that situation, that taser was a use of deadly force because it caused the death of another person. So we have to
even though you didn't intend that.
Yeah, even though
that's something that you have to consider.
Exactly right. And so the courts will always go back and look and see what was the outcome. Did it cause serious bodily injury or death? And you got to be very careful. And if it causes serious bodily injury or death, the law is going to require that you be justified in a use of deadly force. So,
let's hit another one of these myths before we go to questions.
Okay.
And this is one I think Richard was hoping that I would discuss a little bit more than he would, which is, the myth that men can't use force against women in self-defense, right? A man can't hit a woman in self-defense. And, that really, it truly is a myth, right? I mean, self-defense is gender blind, right? I mean, there's nothing in the law that says just because you happen to be of the male gender, you can't defend yourself against a woman who's attacking you.
Yeah.
Now, however, that being said, I think we both have examples of ways in which the law does judge men more harshly. And that's not the black letter law. That's a jury, right? Not just a jury, the police officer on scene, the prosecutor prosecuting the offense. Specifically, years ago, I had a case in which my client was confronted by a woman who was forcefully and unlawfully entering his castle, right? She was trying to get into his vehicle, and she was really belligerent, and it was a really scary situation for him. And he drew his firearm, and he drew his pistol, and he pointed at her. And sure enough, he was the one arrested. Which is, I can virtually guarantee that if it had been a belligerent man trying to get into his truck, he would not have been arrested. Now, the case was dismissed, but, that was a year and a half down the road on the eve of trial, basically. So, and I know you have a good example of this as well.
If I'm thinking of the one you're thinking of, I had a client who was, there's a whole lot of lead up to this, but he was in the process of getting stabbed by, his girlfriend. And so she's stabbing him, and he punched her in the face because she's stabbing him to death. She got charged with aggravated assault with a deadly weapon. That makes sense. But he also got charged with an assault for punching her in the face. For punching her
when he was being stabbed.
Correct. Yeah. And so, and eventually, justice was served, and that case was dismissed. But again, dragged through the system, had to put up a bond, had to hire an attorney. It took away a year and a half of his life. He was actually a police officer, and so it delayed his advancement. It delayed his career. He couldn't, change jobs. I mean, it was very life disrupting. And so that's all to go back and say, while it is a myth, it's a factor. It's a strong factor that is going to be considered.
Absolutely. And I think, you can look at, you have to look at the gender, not only of the person being attacked, but if your attacker the same way, like if one of the parties is maybe elderly or infirm or just, you have to look at your proportionality, your reasonableness, and gender is a factor that goes into reasonableness and proportionality, even though black letter of the law doesn't consider it. And, generally speaking, it is a myth, right, that you wouldn't be able to use self-defense against a woman.
And I think that's a perfect lead-in, for example, from a question that came from Mike. What if you're surrounded by 3 or more people? Their intents to hurt you. At what point are you able to defend yourself? And that goes into the proportionality characteristic. One person versus 3 potential attackers. What does that look like when you're balancing the scales out?
Oh, sure. So, I think, and again, this is all, to an attorney, scary, because up to a jury to decide at what point you were reasonable and proportional. But the more attackers generally that you're facing, the more reasonable you are in acting, and in acting with higher levels of force or potentially deadly force, right? So if those 3 guys are just, kind of coming towards you, it's not immediate yet. But we had a client, we had a client who was jumped outside of a bar by several guys. I don't know if you remember that.
I do.
And he couldn't access his firearm in time, but if he could, they really gave him an intense beating, and he was hospitalized for quite a long time. And, that would have been the difference between his ability, could he have gotten to his firearm, to act in that situation. He could have, I think, acted much sooner than if there was only one attacker. Now, he was actually not charged for use of force in that offense, but you remember he was charged because he had been in a bar with his firearm, and the police decided that the beating wasn't enough. He needed to be charged for that.
Yeah, and it goes back to your example of being featherweight more, and I think about scales of justice here. Our 3 people, obviously, they have the capacity or the opportunity to cause so much more damage than a singular individual. And so what evens out that equation? And that's what is judged on a case-by-case basis. And so it's just, that's the lawyer answer. It's just going to depend. And there's so many different factors
Right.
that get taken into consideration.
Yeah. What do those 3 people look like, right? Are they big, burly guys? Are they 3 teenage girls coming at you,
Yeah,
right?
a bunch of Girl Scouts.
But really, no. I mean, it really, Matt,
It does.
Is it, and think about the other things that factor in too. Is it dark? Where are you? Is there someone around who might be able to help you? Could you get someone's attention? I mean, there are all sorts of things that are going to factor, and that's into the reasonableness analysis of any time you use self-defense, right? But it's, people like to call and they like to ask us, very specific hypotheticals. Like, what if I'm confronted by 3 people and, I do this? And the answer is always, it depends, because of all these other factors that you aren't even considering, that you can't consider until, you're actually in the situation.
Going on, Harold asks, what if somebody's trying to break into your house? Would you be allowed to respond? He says deadly force or force, or do you have to wait for them to get into the house? I get that question a lot. Do you get that question a lot?
I do. And, this is a castle doctrine situation, and it is going to vary state by state. There are some states who say that attempted forceful and unlawful entry into your castle is enough to begin your justification of deadly force. In some states, you are presumed reasonable, so you don't even have to fight that uphill battle of reasonableness. Some states, you think about the states kind of in the Northeast that are very, very restrictive. We're talking about not only do they have to make it inside, but you probably have to order them out before you would be justified in using self-defense, right?
And so it's going to vary by state, and that's why it's so important to go to uslawshield.com. At the very top, there's that education tab. You have to learn the law of your state. Ignorance of the law is not an excuse. And so when we're talking about these legal concepts, we're talking about, we're talking usually about the majority of states, what most states do. But if you live in those really restrictive states with the Second Amendment, with the right of self-defense, think the West Coast, Illinois, the Northeast, you know who you are. But if you're in those states, you really have to know the law like the back of your hand, because they aren't going to give you any breaks.
No, certainly not. And it's not intuitive. We're lucky enough to be in Texas where, generally speaking, a lot of our self-defense law is intuitive. Now, our carry law is not. But, these states are, you really, really do have to know it is going to be held against you in court if you don't.
So 2 different questions. Going back to proportionality, and I think these are good questions. Richard asks, how can a 70-plus-year-old person, what's deadly force to them?
Oh, gosh. So this is, I think, a really, really good one because, you get this, and, in civil law, we call it the eggshell plaintiff, right? So you have this idea that it is dependent upon you, right? You know your person, and you respond reasonably in defense of yourself, knowing, gosh, I have this medical condition. I am unable to defend myself for this reason. And so, if hey, if this guy, gets me down on the ground, he's definitely going to kill me because I'm 70 years old and I'm not going to be able to defend myself. That does factor into your reasonableness analysis. Now, it's not a get out of jail free card, right? And we've seen that with some of our cases as well. But it is a very, very strong factor in reasonableness in escalating your proportionality, right? Now, I would say not your immediacy, because that's, we have a case, I have a case in mind in which, the self-defender was in his 70s. The attacker also, turns out, was pretty close to 70.
But very healthy.
And, it wasn't that the self-defender couldn't have defended himself. It's that he did it too soon.
Right.
And he did it because he's like, I'm not in good health. I'm 70 years old. I have these issues.
Yeah.
But, so your proportionality absolutely affected, your reasonableness absolutely affected. Don't let those things affect your immediacy, because I think that's where people get themselves in trouble.
And what's compacted by this, Victor asked an incredible question. Could you use your firearm to defend yourself if someone, one person punches you? And that is I think a very hot topic that is being, we see the knockout game or the one punch game, or they call it different things. Or if going back to our example with our 70-year-old, what if that one punch takes you out?
Right.
What if that one punch,
that's enough?
Either it kills you or it disables you to a point to where then you have no ability to defend yourself, and this person could just,
they're going to access your firearm now, all sorts of things. Yeah.
And so being able to explain to a jury, hey, if I didn't use deadly force in this instance, I could have been subjected to serious bodily injury or death, or would have been disabled, or, it is an uphill battle, wouldn't you say?
Absolutely. And no one likes to hear that. Who likes to hear that you
have to take a hit?
Right.
That doesn't seem reasonable to me.
It does not. But, and this is not, again, it's not in the law. This is just from our years of experience, if you don't take that hit, if you don't have something to show the jury, whether it's an armed attacker or some serious injuries, you have to be well prepared to explain why you had to act immediately when you acted, and why you feared deadly force, or else you're going to have a tough road of reasonableness in front of you.
So good question. This has come up from a couple of people. Mark, it looks like Rick. All right, so we have this question. It's come up in a couple of different forms, but modifications to their everyday carry. If they upgrade the trigger or they upgrade the barrel. Mark said he recently upgraded his pistol with a red dot, upgraded springs, lowered the trigger pull. What do you tell your clients about modifications to firearms?
Yeah, well, there's 2 buckets, right? We have so many buckets now.
So many buckets.
So yeah, we have things that improve your accuracy, that improve your lethality, that make you more effective with that firearm.
Yeah.
And then we have the other bucket.
Yeah, so that first one I'd call function enhancing modifications. So an optic, great example. Trigger modification, perfect example. Those enhance the function of the firearm. But what's that second category?
Yeah, so those are the non-function enhancing customizations, right? Yeah. Those are the ones we discourage. If it enhances you, right? Modifying your trigger, better optics, lasers.
Even ammunition choice.
Choice of ammunition, right? All of those things. If it makes you better, if it makes you safer, do it. That's what I say. And of course, if it's legal in your state.
Yes.
Which most of these are, right?
Yes.
But so let your defense attorney worry about that. The chances that the prosecution even sort of figures out what you did, lower in some jurisdictions than others, but let us handle that. The only customizations that I really discourage for my clients are the ones that are not function enhancing. Those.
Yeah, some examples of those might be, cheeky sayings on dust covers, engravings around the barrel that say, provocative things. I would say and when I use this term, colorization, non-function enhancing colorization, if you're painting it a flat color or camo or, that's all fine. But if you're painting it to look like a Nintendo gun, those types of things, I can just see the narrative being pulled up in court saying, hey, look, this person doesn't take life seriously. They think shooting is a game. They painted their controller to look like a video game, and this is a human life. So you don't want those types of arguments pulled out in court. And also, that those probably belong on a shelf for display. You don't want to lose that, because if you have to use it in self-defense, that gun's leaving your collection. It's possible that it's leaving your collection forever.
Right. Yes.
And some of those modifications are expensive.
Very true.
All right. So we have, this is coming up a lot in, it's coming up in Houston a lot. Defense of property. We had a couple of different questions about, coming out to burglars at their cars. A couple of different questions about, like a catalytic converter getting stolen, or just people rummaging through their vehicle. What is your instinct when you see, you have a client calls you, say, hey, this happened to me, and this is how it normally comes up for me, is they call me the Monday after and say, this happened to me over the weekend. This is how I responded. Did I act okay? But what are you telling your clients when it comes to, coming upon a burglary, and somebody called it a robbery, but when someone's breaking into an unoccupied vehicle, let's use that as an example. What are you saying?
The law always values life over things, right? Which means that I know we're speaking in very general terms, but this is true throughout the country. If human life is in danger, you are always going to have an easier time acting in self-defense than if you are just protecting your stuff. And now sometimes it's both. Sometimes you come upon a burglary in progress, and then all of a sudden it's you that you're defending as well.
Right.
I had someone who called the U.S. LawShield emergency hotline really recently. He came upon a burglary of his truck in progress. The guy was crawling out of the back window of his truck with a firearm he had stolen from the truck in hand. Now, to me, and he shot him, and ultimately, was not charged, and it went really well for the self-defender. But ultimately, I don't see that as a property crime, as defending against someone burglarizing my truck. That was, you are coming out of my truck at me with a gun in your hand. That's a person crime. Right.
And Steven asked this question. He says, I'm in Colorado. I'd probably let them steal his property, reasonable if, not a human life in danger. But what if he's being carjacked? That's a really good question, Stephen. And at that point, as Emily was talking about, it's not just a property crime, a carjacking, it's not just stuff at that point, because now you're in danger. And so obviously you'd follow the law, the state of Colorado, if you're in Colorado. And so I'm sure they have a castle doctrine with their vehicle. I'm sure they give you extra rights to defend yourself. But at that point, I think it's important to recognize that it's not a property crime. A carjacking is a person crime.
Right. And, there's many states that do give you the right to use sometimes up to deadly force in defense of property.
Yes.
Just because it's there in your penal code, in the black and white law of your state, doesn't necessarily mean it's a good idea. And the reason being, this concept that's been kind of like floating over us the whole time we've been talking about, which is reasonableness. Because ultimately, you get that jury, and do you want that jury to say, would a reasonable person have shot over a catalytic converter?
Right.
And even if, here in Texas, that would be theft in the nighttime, right? So potentially it's in our law that you could do it. But I don't want a client sitting in front of a jury and having a jury ponder that, because there's just a gigantic chance that a jury is going to say, no, a reasonable person wouldn't have done that. Sorry. Now you are going to prison for 99 years.
Yes.
So,
I mean, and a lot of people prepare. They go to the range. They put a lot of, bullets down range, but they don't think about the legal aftermath. And I think that's really important to circle back to. And this is one of those conversations where you have to prepare ahead of time. Is it worth going to prison for the rest of my life over a catalytic converter? I think most people will say no. I'm sure there's a couple of catalytic converter fans out there that maybe, it's worth it to them. But for most folks, that's not going to be worth a trip to prison.
Yeah.
And they don't think about what happens after.
Right. Well, and that's, when we were criminal prosecutors down in Galveston County, one of my favorite defense attorneys, he would say to me, and I didn't really understand it as much as prosecutor, because then our jobs were to, put people into jail who had committed crimes. But, he would say, if you win at trial as a criminal defendant, there's no such thing, right? You can either lose at trial, or the best you can do is a draw. Right. And that's if you're found not guilty, he said, that's not a win, that's a draw, because of everything else you've been through for the 1, 2, 3. I mean, gosh, COVID times now. I mean, I have clients who have been waiting on their murder trials for 5, 6 years at this point because of the slowdown in the system. So it's everything else. You don't win, right?
No. And while it wasn't a topic that we discussed earlier with our kind of general self-defense principles, it does fall in juries like this when you're acting as a last resort, because, when you are acting in self-defense, even when you're completely justified, it is so life disrupting. Oh, yeah. Having to make court appearances every month for years, having to pay exorbitant attorney's fees, having job disruptions. It causes a lot of problems.
Oh, yeah. And then if you get fired or you quit your job, you're not getting a new one.
No, not with a felony pending,
No, absolutely not. I mean, it really is. I mean, we have people, and it's sad. And I mean, I think we can go back to Kyle Rittenhouse because he's the good public example. But you and I each have, probably between the two of us, hundreds of examples of clients whose lives were ruined just to get that not guilty verdict or the case dismissed at the end of the day.
Right.
But it's already gone for them, I mean, and, heaven forbid you get a divorce during that time. There's child custody hearings. You're, have been accused of murder. I mean, it can affect every aspect of your life.
Yeah. So I think that's all to say. It's really important to think about this stuff beforehand. USLawShield.com. Education tab, click on that, learn the resources for your state. You got to know this stuff forwards and backwards. But then, obviously you want to practice at the range. You want to be proficient if you have to defend yourself. But then you need to have a plan in case you're forced to defend yourself. What are you going to do afterward? And that's something that everybody needs to prepare and think about. And I think we're getting the sign. We're running up on time here. But I just want to say on behalf of myself, we're so grateful to spend this time with you. I had a wonderful discussion, Emily.
Oh, absolutely. And if this raised more questions for you, which hopefully it did, I think that means we did a good job if we've raised more questions. Get into that U.S. LawShield library. Look for things like what you should say on a 911 call after self-defense, what you shouldn't say, how to respond. I mean, all of it is really, really good information.
Yes. And if you enjoy this let us know if we did a good job. Make sure to leave us a comment, leave questions, because they source these topics. They source these discussions from the comment section. If there's a topic you want to be discussed, leave a comment. Make sure to like this video and subscribe, because we're going to be doing a lot of these this year.
Absolutely. Looking forward to it.
But until next time, I'm independent program attorney Richard Hayes, independent program attorney Emily Taylor. We had such a great time hanging out with y'all, and we'll see you next time.